As you can see, judgment has just been delivered in respect of the substantive appeal filed by SDP and its candidates. We had 32 grounds of appeal originally. 2 grounds had to be discontinued. 4 issues were formulated for determination. The foremost issue was as regards the ruling of the tribunal that was set aside in its final judgment, the order of 14 February 2024, which ordered INEC to not only bring in beavers machines to the tribunal, but to authorize its accredited staff that was acquainted with its contents to come and ventilate the contents to the hearing of everybody before the tribunal. In the wisdom of the Court of Appeal, they said that the tribunal was right in setting aside its own order, despite the fact that none of the parties before it applied for the setting aside of the order of 14 February 2024, and notwithstanding the fact that the same lower tribunal had reaffirmed that order on 29 February 2024, when the officer of INEC stepped into the witness stand to give his evidence. The other issue which was dealt with by the court was as regards Section 137 of the Electoral Act, as well as paragraph 46, subparagraph 4 of the first schedule to the Electoral Act. That has to do with the fact that the tribunal is empowered to accord probative value to documentary evidence tendered in its final judgment without necessity of being linked directly by any particular witness. In our own case, we did everything possible to ensure that PW24 in particular linked the evidence tendered, the documents tendered. However, in the wisdom of the Court of Appeal, they said that was not done enough. The other matter the Court of Appeal dealt with has to do with the evidence of PW24 and the evidence of PW25, as well as Exhibits 3, P357 and P358. That is to say, the inspection report and the forensic reports. Those reports emanated from the order of the tribunal made on 25th November 2023. The issue of whether the tribunal had power to make that order went all the way to the Supreme Court. And the Supreme Court affirmed the power of the tribunal to have made that order for inspection. However, to our surprise, and in the wisdom of their lordships, they said the tribunal was right in rejecting those exhibits, inspection report that is, as well as the forensic reports that were tendered through PW24 and PW25. In the case of the qualification of the second respondent, we established within the limit of our own human efforts that the second respondent presented forged certificate to INEC. We brought in documents to prove that. We called 3 witnesses, PW2, PW3, PW24, to substantiate that. However, in the wisdom of the Court of Appeal, they said that's a pre-election issue. But I must add to that, both the second respondent, the candidate of APC and APC itself, also filed 2 separate cross appeals. We challenged those 2 appeals, cross appeals, and those cross appeals were dismissed. So on one hand, the appeal of the appellants, SDP and its candidate, was dismissed, while on the other, the 2 separate appeals of APC and its candidate were also dismissed. We believe that this may not be the end of the story, because democracy in our country is on crutches. It requires redemption, and we are hopeful that the final court of the land will step in and redeem the situation so that our future and our democracy will be safeguarded and protected going forward.
Excellency, yes. So what's the reaction to it?
Obviously, my reaction is one of glee. We are very pleased that all issues regarding the appeal were resolved in favor of the second respondent. From the erudite judgment, you can see that he was adjudged to have been qualified, and all the issues raised by the appellants, that is the SDP and their candidates, were pre-election issues tied to the nomination form which he submitted. And all those issues also have been raised within 14 days of the publication of the nomination, which they failed to do. In any event, they were not able to even bring evidence to show what was presented and whether the document qualifies as a certificate for the purposes of the Constitution. Then on the issue of non-compliance, they hinge all their case on a witness who testified without a witness deposition from the authorities of peterobi and all the series of cases of the Supreme Court, which are quite clear on the point that a witness who does not testify with a front-loaded deposition is not a competent witness. Whether the trial court was at judgment realized it made an error in admitting the document, it can expunge same at any time, and that's the take-home from this judgment. So we are very pleased with it, and we are very grateful. We look forward to the next step to be taken up from the appellants.
Thank you very much. My name is Abdullahi Bello, All Progressive Congress, Kogi Chapter Chairman. I have the pleasure to attend the appeal judgment this afternoon. And I think I'm quite pleased with the outcome of the judgment. Last week, we were all here, and I said I have confidence in the judiciary of this country because it has really vindicated the mandate of Usman Ododo that was freely given November 11 by the people of Kogi State. I thank them for a thorough and well-delivered judgment. All the agents